Hello landlords, it's Ernie, and over the next few weeks we're going to be talking about appeals and what you need to know about those appeals. Today we're talking all about how many times your tenant can actually appeal your judgment. Let's get started. Those of you who follow this channel know that every week we put out videos having to do with landlord-tenant law. If you're interested in getting updates about when these videos come out, don't forget to subscribe. If you like the content that you're watching here, please comment below, give us a like, and help support this channel in that way. So today is all about tenant appeals. And the basic question has to do with how many times can a tenant appeal a judgment in an eviction case? Well, as everybody knows, or you should know, all eviction cases start in the justice court. So you are in the justice of the peace in the precinct where the rental property is located. Now, what this means is that every case starts on a very, very local level, but it can move up. So here's the good news if you happen to be a commercial landlord. Your commercial tenant can only appeal once. So the appeal can go from the justice of the peace to the county court, and that's where a commercial appeal ends. If a commercial tenant attempts to appeal up to the Court of Appeals or beyond, those appeals are essentially moot because they're just not proper under the law. They are allowed one appeal. However, for residential tenancies, a tenant in a residential situation filing for an eviction can appeal really 4 times. I mean, that's mathematically possible. That would be the first appeal from the justice court to the county court, second appeal from the county court to the Court of Appeals, the third would be from the Court of Appeals to the Texas Supreme Court, and then theoretically, someone could appeal from the Texas Supreme Court to the U.S. Supreme Court. I don't see that, but it's mathematically possible. In my years of practice, I've seen that most cases that start off in the Justice Court do not get appealed. It might be fewer than 25% of the Justice Court cases that go up to county. Of those, maybe 3% go from county court to the Court of Appeals, maybe fewer. And then of those, I've only seen one case in 11 years go from the Court of Appeals, an attempt to go up to the Texas Supreme Court, but the Texas Supreme Court declined to hear it. And so we're going to talk about how it gets from one level to the next. And I've never heard of, and I'm sure if I do enough research, I can find an eviction case that would have gone to the U.S. Supreme Court. That's got to be extremely, extremely rare, especially since the Supreme Court of the United States and the Supreme Court of Texas have discretionary authority. They are not required to hear something that's brought to them on appeal, especially if the issues are already well decided in the courts of appeal or are well established in the law. So let's talk about that first appeal, which is the most common one. Again, roughly about 25% of these go from justice court to county court, and that's why many landlords who routinely bring eviction cases to the justice court are shocked. It's like most of my cases just end with the filing. You'll find that filing the eviction often motivates the tenant to simply move, right? Many move at the notice to vacate. But there's something about the court's involvement that really motivates tenants to go ahead and leave before trial. And so, many landlords recover their property and never even show up to the courtroom. But for those who do and whose cases are appealed, they're a little lost in the county court sometimes. And so they'll give us a call and ask for assistance. And one of the things that most landlords are confused about is why the tenant gets an appeal in the first place? Like, what went wrong? Why are they allowed to appeal if everything was done properly? Well, the simple answer is because everything that comes out of the justice court is appealable. And so the way that the rules are written for justice court, there is no record. The process is designed to go super fast. It's technically in the books to go in 21 days. Right now we're seeing some cases go 2 and 3 months. But the rule is you're supposed to get your eviction heard and ruled on within 21 days from the day of filing. Again, that's been mathematically hard to do during the pandemic, but when everything comes back to normal, that time frame should be reset so that evictions can be heard in a speedy process. But because of this process, each of the rulings that comes out of the justice court is subject to review by a higher court, in this case to the county court. And so if you're asking why do they get this opportunity if essentially there was no error, it's simply because you get a free one. The first one is free. You don't have to cite any error. There doesn't have to be a good reason. The tenant gets, as a matter of right, that first appeal. However, the second appeal does require error, and the tenant needs to have preserved that error in order to discuss it on the next level. So from county court to the Texas Court of Appeals, the case moves into a court of review of what happened in the trial at the county court level. So remember, in the justice court level, there is no stenographer. There's nobody there typing out, what goes on in this case, and so there's no record. You'll have a record of what was filed, and that's it. But what happened in the trial itself, nothing is preserved, and so the case is heard at the county level on a de novo basis, which means it's brand new, as if nothing happened in the justice court. Now, in the county court, a record can be preserved, and you'll see that there is a court reporter who actually types down everything that is said. Now, this happens if, in fact, the parties request a record. If no record is requested, it's going to be very difficult for the Court of Appeals to review what happened in that trial. But assuming that a record was requested and all the words that were spoken at the trial are preserved for review, then the Court of Appeals can look at not just what was filed, but what was said and what formed the basis of the judge's ruling. And that's what gets reviewed, is the substance that led up to the ruling. Was there an error? In other words, did the court get something wrong? These are the facts. This happened on day 1, this happened on day 2, this happened on day 3, or this is what the document said, or the record shows that payments were made on such and such date, or that no payment was received on such and such date, or that the notice was delivered. All of these small facts lead up to a judgment. And if the court gets it wrong or interprets the law incorrectly, and we've talked about that on this channel, some courts simply interpret the law differently. And if the Court of Appeals disagrees with the way that the judge has interpreted the law, that judgment could be reversed. And so the Court of Appeals for the state of Texas review the facts of these cases. And if a tenant files an appeal from the county court up to the Court of Appeals, number one, they will have had to cite an error committed by the judge in the county court. And then number two, they would have to prove that they preserved that error in the record. And then number three, they would have to inform the Court of Appeals, not just that something went wrong, what went wrong, but how the court should have ruled, right? And so generally speaking, this is where the research comes in. And if the tenant is pro se, which means that they have no attorney, they're in there by themselves, it's very difficult for a pro se tenant to go and adequately, research a case and say, well, this is what the law says, this is what courts have said in the past, this is what this court said, and so this is why you, Court of Appeals, should change the ruling, right? The judge went this way, but they should have gone that way, and here's the reason why. And so because tenants are used to the appeal from the justice court to the county court, that step to cite the error, cite case precedent, and then to propose what the court should have done and why, that's some pretty complicated stuff. Now, that being said, tenants can figure this stuff out. It is possible for a tenant by themselves to, write a perfectly good brief to the Court of Appeals and even win and get, a judge reversed. But there really has to be some pretty big error. If what they're saying instead is, I disagree with how the court used its discretion, most of the times that's not reversible error. The fact that a court has a pretty wide breadth of discretion means that they could go all the way over here or go all the way over here, but as long as they're within that boundary, the Court of Appeals is not going to reverse them. Now, if someone seeks to go from the Court of Appeals to the Texas Supreme Court, that's where they're going to have to get permission to get through the door, because the Texas Supreme Court just isn't obligated to hear your appeal, especially if the Court of Appeals got it right. And so if in the discretion of the Texas Supreme Court, you say, no, sorry, Court of Appeals, you got it wrong, I'm gonna appeal one more time up to the Texas Supreme Court, the Texas Supreme Court can, slam the door right in your face and say, nope, not gonna happen. Generally speaking, they're not going to cover a case that has already been decided or facts that have already been decided a million times over. And so if you're saying, well, the judge abused their discretion and they shouldn't have done it this way, they should have done it that way, and if it's a fact pattern that the Supreme Court has heard a million times, they're simply not going to spend the time on this kind of appeal. And the reason is simple, because this kind of appeal has already been decided. And so because there is a long history of decisions going in one direction, and the courts, prefer that things go in a very specific direction and stay within these specified boundaries, because of this, they're going to decline to hear that case. The same is true for the U.S. Supreme Court, but to a much bigger degree. If you happen to go from the Court of Appeals to the Texas Supreme Court, and the Texas Supreme Court hears your case and you get a ruling, and somehow it involves a federal issue that you believe should be appealed up to the U.S. Supreme Court, then yes, that is possible. It's highly unlikely that an eviction would involve such an issue that hasn't already been decided many times over, and that is so important that the U.S. Supreme Court would take it on after the Texas Supreme Court has ruled on it. Again, these things are mathematically possible, but are just not very likely. So the majority of you landlords who are involved in an appeal are going to be involved on the county court level. And the reasons that we cite for understanding how an appeal works out is so that, number one, you prepare adequately for what will be preserved in a record. You want all of your exhibits. When you go from justice court to county court, there is a bit of a shock because the formality is much higher in the county court. You want all of your exhibits properly prepared. You want your argument to be succinct. You want the testimony, if it's recorded especially, you want your testimony to make sense. You want to be able to demonstrate to the court that you have all the elements of proof to sustain a judgment, and to make that judgment pretty rock solid when it comes to even the threat of an appeal. And so you set up your case so that a court can, upon review, say, yep, they checked mark 1, 2, 3, they got all the steps right, all their evidence lines up with their testimony, there is no reversible error here. The other thing to think about is the judgment itself. There are things you can do in your judgment to prepare yourself for a potential for appeal. One of them, and this is probably the most important one, is the setting of a supersedious bond. The supersedious bond is set up to protect the landlord during the course of an appeal. And in Harris County, it is very common for a supersedeas bond to be set at 10 times the monthly rent. So you definitely want to establish rent, and then when you're seeking your judgment, you definitely want to request that a supersedeas bond be put in place of 10 times the monthly rent. So if you have a $1,000 a month unit, you'd like a $10,000 supersedeas bond, which would require that the tenant would have to pay within 10 days of the judgment this bond amount in order to remain in possession of the unit during the course of the next appeal. And this tends to be the best deterrent against any tenant filing that second appeal, is this supersedeas bond. Now, can it be lowered? Unfortunately, it can. Can it be delayed or extended? Can the county court get things wrong and, allow a party to remain in possession even without payment of a supersedeas bond? Yes. Now, all that's reversible error in your favor, but yes, sometimes these things go haywire. There is no such thing as an absolutely foolproof method. We advise based on what's worked in the past, but with the warning that things go wrong, and sometimes judges make decisions that end up harming landlords and make this appeal too easy. But for the most part, the supersedeas bond does come down and is an effective way to prevent 10 times rent due in 10 days. Most tenants are just not going to be able to do that. Well, I hope you've learned something from this video. I hope you now understand why it is that a tenant can appeal and just how far they can go, and the kinds of things that prevent a tenant from going up the ranks in an appeal, and what you can do to be better prepared in the event that you're facing an appeal. Because the truth is, if you're prepared for what will happen in the future, you're better prepared to bargain in the present. So I tell landlords this all the time: you can expect an appeal from the justice court to the county court to go anywhere from 30 to 60 days. Getting a writ of possession is going to be an additional 1 to 3 weeks. So if already this could go an additional 90 days, it may not be so difficult to bargain with your tenant for, say, 3 weeks from the justice court to the county court, because they could appeal and quadruple that. Knowledge is power, and so the more knowledge you have, the better off you're going to be. In fact, you'll see that I'm going to make a series of videos that have to do with an appeal and strategies you can use to better prepare yourself for that appeal and to be successful after that appeal has completed. There's a video here that YouTube seems to believe you will enjoy. Please watch that. You'll see a picture of my face here. Click that if you haven't subscribed yet. But until next time, happy leasing.